So yes, today we are going to take up the next three presumptions. The first one is presumption relating to jurisdiction. So what is the presumption regarding jurisdiction? It is that from reading a particular provision with respect to jurisdiction, okay, it is neither to be enlarged nor to be decreased, okay. It is what it is, okay. So it is not to be enlarged or not to be decreased, okay, with emphasis more on not to be decreased, okay. Why is that? So underlying idea is that no one should be remediless, okay, and remedy should be provided in a particular court, okay. And that's why the idea that it is not to be decreased. So that's where the emphasis is. So statutes should not be read so as to take away the jurisdiction of superior courts. So that's the idea. Remember, in the last presumption we discussed the same thing, okay, that when it comes to substantive matters, there is substantive right, then there is a presumption as to prospective application, and only in procedural matters, okay, there is no such presumption. Well, remember the same idea here, that idea is also applicable. So when it comes to a forum before which you can have recourse to, that is not to be decreased, okay. So that's the idea. So a statute should not be read so as to take away the jurisdiction of superior courts, or so as to extend that jurisdiction by giving a right of appeal, okay. So if it is not there, then obviously that's not to be assumed. However, if it is not taken away, then presumption will be in favor of that right, okay. So that's the idea. So the jurisdiction of ordinary courts of judicature is not to be taken away by putting a construction upon an act which does not clearly say that it was the intention of the legislature to deprive the courts of their jurisdiction. So that's the idea. If two readings are available, equally plausible, one that is for jurisdiction, the other that is not, then the one that is for the jurisdiction is to be preferred. So that's the idea. If it is taken away, it has to be taken through clear words. It's not a question of intendment there, okay. So there's a maxim that talks about the same. Just share this with you here. So it goes like this: boni judicis est ampliare jurisdictionem. So it basically says that it is the duty of a good judge to enlarge his jurisdiction. Now, a word of caution here though, that when we talk about enlarging jurisdiction, it should not be against what is clearly expressed. That's already there. We have discussed this. But when possibilities are there, one that reduces, other that enlarges, then the idea is that, well, the subject should have recourse to more forums, okay. That's the idea. Hence, this particular maxim, that is boni judicis est ampliare jurisdictionem, it says that it is the duty of a good judge to enlarge his jurisdiction. So it denotes that a good judge's duty is to amplify the remedies of the law. So people should have more chances of getting remedies. That's the idea. So Viscount Simmons, referring to Maxwell, okay, that's the source, okay. Viscount Simmons says, it is a principle not by any means to be whittled down that the subject's recourse to Her Majesty's courts for the determination of his rights is not to be excluded except by clear words. So yeah, what I was trying to explain earlier, that there should be more options, okay, of remedy for Her Majesty's subjects. The same applies here. The one interpretation that enlarges recourse to remedies, that that's the one that is to be preferred to the one that reduces. However, yeah, when these possibilities are there, but if the clear words do not allow that, okay, then definitely that's not to be done. So in this case, by the name Dobe versus Dobe 1963. So in this particular case, we are concerned with, you will find this in this book, okay, that is G.P. Singh. This particular case has been discussed there, where we are concerned with section 12.3 of Matrimonial Causes Act 1950. And the provision goes like this. It says, if the spouse obtaining a decree nisi of divorce did not make an application for it to be made absolute 6 months after the trial, then the other spouse could make an application within a further period of 3 months, and if the circumstances warranted, obtain a decree absolute. So you see that there's a jurisdiction which has been created in a situation. Now, are we to assume that because this particular jurisdiction is there on this matter, then other jurisdictions are removed? So the question is, did this particular provision, oust the jurisdiction of the court to substitute a decree of judicial separation for a decree nisi? Okay. So decree nisi is what is new here. Okay, creation of this, are we to assume that replaces the court's jurisdiction for decree of judicial separation? Well, it was held that no, that's not the case. Okay, so court has the other option as well. So creation of one particular jurisdiction wouldn't remove the other. That's what has been held in this particular case. So similarly, just like that, Lord Denning had said in R versus Medical Appeal Tribunal, Ex parte Gilmore, 1957. In this particular case, Lord Denning had said, the remedy by certiorari is never to be taken away by statute, except by most clear and explicit words. So even when there is a finality of decision, even then certiorari would apply. That's unless it is taken away explicitly. That's what has been said. So he says further that the word final is not enough. That only means without appeal. So that is not there. Appellate jurisdiction is not there. It does not mean without recourse to certiorari. It makes the decision final on facts, but not on the law. Notwithstanding that the decision is by statute made final, certiorari can still issue for excess of jurisdiction or for error of law on the face of the record. So even when finality is there, that is to be understood merely as without appeal. But that does not mean that if there is error in law, then or excess of jurisdiction, then there is no intervention by the court. So that's what has been said, that certiorari, even in such situation, even in the face of finality, even through statute, would still apply unless that is taken away by clear and explicit words. In another case by the name Prix Granite Company Limited versus Minister of Housing, Local Government, 1960. Just a second. In this particular case, the appellant company here, Prix Granite Company Limited, sought a declaration that it did not require development permission for carrying on of certain quarrying operations. So what they sought is that it did not require development permission for quarrying operations. Now, this we are to look at in the context of Town and Country Planning Act 1947, Section 17, that says, if any person who wishes to carry out any operations on land wishes to have it determined whether an application for permissions in respect thereof is required under this part of the Act, he may apply to the local planning authority. So this is the jurisdiction which is created to determine the to determine that question. Further, it says, an appeal lay to the minister, okay? Who is that? Okay, so who might also call in, so it's a different forum, okay? It says, who might also call in the question before the local authority, had come to its decision. So before the local authority comes to its decision, appeal may also lie before the minister and could be decided. And his determination was to be expressed as final. Okay, now finality is there. So what happens then? How is this to be interpreted? So the House of Lords held that the provision by the Act of a special procedure for cases of this sort and the statutory finality of minister's decision did not take away by implication. So no case of implication, that means it has to be clearly expressed. So what did it not take away by implication? That is the old and, as we like to call it, the inalienable remedy of Her Majesty's subjects to seek redress in court. So despite this finality, by implication it will not take away the subject's remedy before Her Majesty's courts. So if it is, so as we discussed earlier, if the jurisdiction is to be taken away, there is no implied taking away of the jurisdiction, unless that's the only implication. So the idea is that if jurisdiction is to be taken away, even if there is finality, however, if there is alternative, avenue available, if that is not taken away, that cannot be taken away by implication. It has to be taken away only by clear words. So that's what this particular, presumption means, presumption as to jurisdiction. An implication of the same presumption as we are discussing is that plain words will oust jurisdiction. So as we discussed, there is no implied taken away unless there is only one implication. Okay, if ambiguity is there, then it will be for the jurisdiction, and certiorari lies, okay, even in case of finality. And if alternate avenues are there, by implication that is not taken away. It has to be taken by clear words. So jurisdiction can be taken away, but it can be taken away only by plain, clear words. If that is there, then that can oust jurisdiction. So that's what this is all about. Plain words will oust jurisdiction. So we have a case by the name Baraclough versus Brown, 1897. So this is the case, okay. Now what happened here is that in this particular case, statutory undertakers of a harbor were empowered to remove any vessel sunk in the harbor and to recover expenses of doing so from the owners in court of summary jurisdiction. So what it can do, remove vessels sunk in harbor and recover expenses. How? Through the court of summary jurisdiction. So it was held in this particular case that they, the undertakers of the harbor, could not recover the expenses as damages at common law in high court. Okay, so it clearly says where it can get it from and how. It can only recover expenses, no mention of damages. Okay, so that's why it was held that they could not recover expenses as damages at common law in high court, nor could they have declaration that on the true interpretation of the act they were entitled to their expenses. There is no such possibility from the language of the provision of the statute. So that's why no question of intendment there, no question of implication there. So Lord Herschel had said in this particular case that I do not think the appellant can claim to recover by virtue of the statute and at the same time insist upon doing so by means other than those prescribed by statute, which alone confers the right. So here's the catch, as you can see in the quoted remarks of Lord Herschel. So idea is this, that if you had a common law remedy already, which already existed, then there is a presumption in favor of continuation and existence of that remedy. It cannot be taken away merely through unclear words or through implication. It cannot be taken away. The presumption is in favor of enlarging the jurisdiction, in favor of the jurisdiction. So more avenues should be open. Subjects of harmless should not be without a remedy. That's the idea. But that's when the right already existed. However, if a new right is created by virtue of a new statute, and the statute itself provides the remedy, okay, but does not provide other remedy, then by implication, those other remedies are not to be assumed if that is not allowed by the statute. But if it is allowable, then obviously the same thing applies. So that's why Lord Herschel says, I do not think the appellant can claim to recover by virtue of the statute and at the same time insist upon doing so by means other than, because the right was created by the statute, has to be confined to the statute. That's why it says, other than those prescribed by the statute, so the statute alone confers the right. So the remedy has to be what the statute provides. So that's what this presumption is all about. Now this presumption also means that there is a presumption against, creation of new and enlarging existing jurisdictions. Just like the previous one that we discussed, plain words will oust the jurisdiction. So there is a presumption against creation of new and enlarging jurisdiction. A few important cases will explain that. So there's an important case by the name Seaworld versus Veracruz, 1884. In this particular case, the House was asked to rule, upon the nature of fatal accident claim. So House of Lords being referred to here. The House was asked to rule upon the nature of a fatal accident claim as established by 1846 Act, known as Lord Campbell's Act. Question was it such as to be within the jurisdiction of the Admiralty Division? So with respect to that, Earl of Selborne explained the maxim that is, generally especialibus non derogate, and explained that now if anything be certain, it is this, that where there are general words in a letter act capable of reasonable and sensible application without extending them to subjects specially dealt with by earlier legislation, you are not to hold that earlier special legislation indirectly repealed, altered, or derogated from merely by force of such general words without any indication of a particular intention to do so. So you see, that's clearly an example of presumption against creation of new and enlarging jurisdiction. It does not address that directly, but it can be understood. So what is the presumption? The presumption is that if it is not there clearly, then there is no new jurisdiction. And so would be the case, it is expandable only where it is a possibility, If that is not there, if the possibility is not there, then the same cannot be expanded, So there is a presumption against enlarging that which is existing, So in this particular case, the question is the application of this rule generally, especially was non-derogate, and what is that? So it basically means that a general provision will not, nullify something, a law which is specific. That's the idea. So in that context, there are two different acts we are to imagine. One that is general but comes later, and there is already a specific legislation. So how to apply the same? So it says that now if anything be certain, it is this, that where there are general words in a later act capable of reasonable and sensible application without extending them to the subjects specially dealt with in earlier legislation. So we are not to expand the meaning of the later, general words in order to negate the specific jurisdiction under a previous specific legislation. So that's the presumption against enlarging the jurisdiction. So now if anything be certain, it is this, that where there are general words in a later act capable of reasonable and sensible application without extending them to the subjects specially dealt with in earlier legislation, you are not to hold that earlier and special legislation indirectly repealed, altered, or derogated from merely by force of such general words, okay, without any indication of particular intention to do so. So if that is to be done, if that specific jurisdiction is to be taken, then it has to be done through clear words. So mere existence of general words in a subsequent legislation in itself will not take away the specific jurisdiction, because that way it will negate many laws, okay? And if that was the intention, that will be made very clear in the later general legislation. So yeah, that's the specific situation where there is a presumption against the creation of new and enlarging existing jurisdiction. So see here, okay, do not get confused here. The presumption is always in favor of the subjects, okay? That's how it is to be looked at. The presumption is to be treated in favor of the subjects. So similarly, in India as well, for example, in CPC, Section 9 refers to something similar, okay? It refers to courts to try all civil suits unless barred, okay? So the jurisdiction is like that. It can try all civil suits unless that is clearly barred, okay? So if not barred, then whatever the civil suit, nature of the civil suit, okay, it comes within the jurisdiction. So that's the kind of, so it goes clearly with the presumption as we discussed, okay? Says the court shall, subject to the provisions herein contained, have jurisdiction to try all suits of civil nature excepting suits of which their cognizance is either expressly or impliedly barred. So it does not lay down exhaustively that these are the matters in which there is jurisdiction. It says that, well, that which is clearly expressly or impliedly, implied, as you know, clear, that's the only implication. Unless it's barred, the idea is that all other, all matters of civil nature will be within the jurisdiction, okay. So that's there, okay. So the legal provisions excluding the jurisdiction of the civil courts and conferring jurisdiction to tribunals must be strictly interpreted in such a way that as far as possible the jurisdiction of the civil courts are not taken away. So that's the idea, okay. So if the jurisdiction is to be taken away from the civil courts, it has to be taken away through clear words. Now if a jurisdiction is created in a tribunal and it does not explicitly take away the civil court's jurisdiction, in such situation we are not to assume that the jurisdiction of the civil court is taken away. Even then, as you know, certiorari, unless it is clearly taken away, even if jurisdiction is created in alternative platform, certiorari would still remain, would still apply. So that's the idea, that is the presumption in favor of jurisdiction, okay. So it is in favor of the subjects that we have to understand this. However, not to the extreme extent as we discussed, okay, when it is taken away clearly through plain words, or there is only one implication, then obviously that's that is to be allowed. Now the rule with respect to the same has been laid down in the case by the name Raja Ramkumar Bhargava versus Union of India 1988. In this particular case, you will see the elements with respect to this particular presumption has been laid down, and those are, so the following are the certain guiding considerations, okay, for exclusion, okay, implied exclusion of civil courts jurisdiction. And how are to assume that? Well, clearly, when it is clearly expressed, there is no problem. When are we to assume that there is implied exclusion of civil courts jurisdiction? So following are the situation. So we are to look into whether a right not pre-existing in common law has been created by the statute. Because if there is a common law right, then you know the maxim, where there is a right, there is a remedy that applies in common law matters, okay. So first thing we have to look into is whether a right not pre-existing in common law has been created by the statute. So statute might codify that what already existed in the common law. So if not, that's what we have to identify. Then what? Then we have to see whether that statute itself provides a machinery for enforcement of that right. So if new right is created, the machinery itself may provide the act itself may provide the machinery for enforcement of that right. Then the third one is both right and remedy created uno flatu. So the right and remedy are referential to each other. They are created at once, okay, referring to each other. And then whether there is a case of finality, okay, whether the statute says that, well, this is the finality of the jurisdiction, okay. So if a finality is intended to the results of the proceedings under the statute, okay, if that is the case, and if the rights did not already pre-exist in common law, okay, and machinery for the enforcement is also created by the statute, and both the right and remedy refer to themselves, then we are to assume that there is an exclusion of jurisdiction, even though it is not clearly mentioned anywhere, but that is the only implication of that. So this is the guiding rule that the judges have to keep in mind to apply that particular presumption. Okay, it's not the presumption to exclude the jurisdiction of the civil code through implication. So, in a case by the name Radha Kishan versus Ludhiana Municipality, year 1963. In this particular case, Justice Subbarao held that conferment of special jurisdiction on a tribunal is not sufficient in itself to exclude the jurisdiction of the civil courts. It should either bar the jurisdiction expressively or provide for liability not existing before, as we just discussed. Okay, it's a new liability, did not exist before, or a special or particular remedy to the aggrieved party. Okay, in such cases, the separate remedy provided shall be followed. So that's something we have to look for, whether the right had already existed or not, whether the remedy has been created by the statute, whether the right remedy refer to them, each other. Okay, and then yes, there is a presumption there is a presumption in favor of exclusion of the jurisdiction. Otherwise, not. And obviously, the finality remains there. Okay, if not, but even then, certiorari might still apply unless that is also taken away. So it further said, okay, that even in such cases, the civil court's jurisdiction is not completely ousted. A suit in a civil court will always lie to question the order of a tribunal created by a statute, even if its order is expressly or by necessary implication made final. Then when is that? Okay, it says, if the said tribunal abuses its power or does not act under the act, but in violation of its provisions, then the civil court jurisdiction will still be there, despite the finality. So that's the first presumption for today. So was it understandable to all of you?
Yes, sir.
Okay.
Yes, sir.
Okay. So it's pretty easy. You are to presume in favor of the subjects. Okay, remedies in favor of the subjects. The next important presumption is presumption against intending injustice or absurdity. Now, this is something that we also discussed in jurisprudence, if you remember. Dworkin talks about it in Riggs versus Palmer. Okay. Kind of like this, but there's another presumption that also. So yes, the other presumption. Sorry, it's not this one. The other presumption, that is permitting advantage from one's own. So yes, let's first discuss this one. Presumption against intending injustice and absurdity. So yes, there is, and how does it apply? So if there are two readings possible of a provision of a statute, and one reading seems to lead to absurd outcome, or seems to lead to injustice that we cannot imagine the legislature to do. Okay, then we are to only if allows two different interpretation. Now this is something that is not new for you. We started with this. The purposive construction, mischief rule, all those talk about something like this only. Okay, the rule of absurdity that we discussed earlier. So that's there, the golden rule that we discussed. So that's what we are discussing here again. Okay, so there are two interpretations possible. One that leads to injustice, something that is absurd, okay, doesn't make sense. Okay, how could the legislature have intended something like this? Okay, and however, another interpretation is possible that does not lead to such outcome. Then the presumption would be, because both are there, okay, then the presumption would be in favor of legislature not intending injustice and absurdity, because we are to assume that the legislature doesn't intend to do injustice, doesn't intend to be absurd. So the court is to go with the interpretation that avoids such injustice and absurdity. However, we are not to assume at the same time that the legislature cannot imagine that which is absurd or unjust. Okay, so that means at the very first instance, without any caution whatsoever, the judges are not to presume against legislature intending that which appears to the judges to be unjust. Okay, no, not that. But when two different equally plausible, equally allowed interpretations are there, one that is lead to injustice or absurdity, other one that doesn't, then the one that doesn't is to be presumed. That's the idea. So in Arrow Shipping Company Time Limited, says Improvement Commissioners 1894, I think, yeah. So in this particular case, okay, it was said that a sense of the possible injustice of an interpretation ought not to induce judges to do violence to well-settled rules of construction. But, remember all the literal rule that we discussed, that's what's being referred to. But it may properly lead to the selection of one rather than the other of the two reasonable interpretations. Okay, so which one? The one that is against intending injustice or absurdity. So that's what has been said. Again, in Ree Wilson's Wills Trust, okay. Just a second. In this one, it was said that if the court is to avoid a statutory result that flouts common sense and justice, it must do so not by disregarding the statute or overriding it, but by interpreting it in accordance with judicially presumed parliamentary concern for common sense and justice. So as we discussed a little while ago, fancier way of saying that it is not to, we are not to assume that the parliament cannot intend, that which appears to us to be, unjust. Well, it might do so. So, for example, taking property, etc., might seem to me personally as unjust, okay? But then the parliament may do so for whatever reason, okay? So in such case, the very first instinct should not be that, well, parliament couldn't have done so, no. But when there are two interpretations possible, then the one that, that is against, the interpretation that is against injustice, absurdity, and absurdity is the one to be, applied. Now, judges have to be extremely cautious here. So that's what, the idea is. And yes, in the readings that I have shared, you will see the question will be raised that why is it that we are to assume that the parliament cannot, intend that which is absurd? Why are we to, presume against that? That question will be discussed in one of the papers that I have shared. We will discuss about that later. So, in another important case by the name Calder versus Hellkit, 1840, in this particular case, East India Company Act 1780 protected magistrates in India from actions for any wrong or injury done by them in the exercise of judicial office. Okay. Now, to what extent do they have this immunity? Do they have this protection? So it was held that the exemption, from liability is applicable only when they are acting in bona fide, cases in which they by mistake exceed their jurisdiction. If it was something malified, intentional, then obviously the immunity does not apply. So yes, the presumption against intending injustice or absurdity. So if there could be two different interpretations of the same, that that they're immune from whatever injury they may inflict, or the other would be only in those cases where they are bona fide, okay, and by mistake thinking that they're within their jurisdiction, but they in fact exceed. So only in that situation. So which is the one that seems to be reasonable? It's the later that seems to be reasonable. So that's the one that is to be preferred. So that's the presumption against injustice or absurdity. Now, as I was telling you guys similarly, you have a presumption against impairing obligation or permitting advantage from one's own wrong. That's the common law, presumption. And that's the one I was referring to earlier, as Dworkin talks about in Riggs versus Palmer, if you remember. So that's the idea. It's a common law presumption, which you will find in many different cases, that has been, where the same has been held. So Maxwell says, on the general principle of avoiding injustice and absurdity, any construction will, if possible, be rejected unless the policy of the act requires it. So yes, the legislature can still do that if it wants to, if that is the policy. However, if it would enable a person by his own act to impair an obligation which he has undertaken, or otherwise to profit by his own wrong. So if that is not allowed by the policy of the act itself, that is not to be assumed. Okay, so there is a presumption against impairing obligation. So you cannot impair your obligation through your own action. Okay, there's a presumption against that. You have studied this in detail in law of contract already. And permitting advantage from one's own action. So in the case by the name Kish versus Taylor, 1911, in this particular case, it was said that a man may not take advantage of his own wrong. He may not plead in his own interest, a self-created necessity. So in a case by the name Bolting versus Association of Cinematograph, Television and Allied Technicians, 1963, Queen's Bench decision. In this particular case, we are concerned with Section 4 of Trade Disputes Act 1906, and it prohibits actions in respect of any tortious act alleged to have been committed by or on behalf of the trade union. So that's the immunity which has been created. What is it? So prohibition of actions, okay, in respect of any tortious act alleged to have been done or committed by or on behalf of the trade union. So what is the limit of that? Okay, so it was held that it didn't prevent the court from granting injunction to prevent an intended injury. So yeah, there is no cause of action after it has been done, but that does not mean that the court didn't have the the jurisdiction to grant injunction to prevent any such intended injury. So yeah, how does the rule apply? So you see that they may commit something, okay, some tortuous act, and then also benefits from it because there is a protection. So it was held that, well, that does not mean that there cannot be any way to prevent that from happening. So that's how the presumption has been applied in this particular case. The last presumption is presumption against intending what is inconvenient or unreasonable. Now this is to be taken with extreme caution. Not in every case, if the judges think that, well, something leads to inconvenience, it is to be avoided, but only in extreme situation. So when? That would be where, if the words are applied literally, that would defeat the obvious intention of the legislature and produce a wholly unreasonable result. Okay, so these three presumptions are similar, as you can see. Only in extreme cases, where if the literal rule is applied, then it would defeat the obvious intention of the legislature. So we can say from the the literal alleges that, well, this is not what the legislature could have intended. So if we go like this, if we apply the literal, literal alleges. from having read the statute, it seems that something the legislature could not have intended. But if we go by the literal, rule, okay, literal words, then, well, it seems to defeat the intention of the legislature, okay, and produce a result which is completely unreasonable. Now, the degree of unreasonableness is extreme, okay, not everything that the judges consider unreasonable. So in such situation, says we must do some violence to the words and so achieve that obvious intention and produce a rational construction. Now, this is something as we discussed already in the purposive construction. So the same here. And what is it? This is the presumption against intending that which is inconvenient and unreasonable. It says inconvenience and unreasonableness must be looked at in the light of the state of affairs at the date of passing of the statute, not in the light of the subsequent events. Okay, so the statute is to be understood in the light of the state of affairs as it existed when the statute was passed. Now, this is clearly nothing new, but something that we already discussed as exceptions to the strict application of literal rules. So there is a presumption against that application of that rule if that leads to that which is clearly inconvenient and unreasonable, something we cannot expect the legislatures to intend. Only in that situation violence to the words can be done. So that's the last presumption, that is presumption against intending that which is inconvenient and unreasonable. So with that, we almost come to a conclusion of the conceptual topics that we have in the syllabus. I think there are one or two that I have missed. I will, in the next class, complete them, and then afterwards we will start our readings. I will assign readings to some of you, and then you will make presentations, and I'm always here to intervene and help you out with that. So that's how we will proceed from now onwards. So any confusion that you might be having with respect to what we discussed today or any other topic that we had discussed earlier, you may raise them now. Was it understandable? Yes? Okay.
Yes, sir, I missed my attendance.
Attendance is later. Am I asking you questions about your attendance? I'm asking something else. So it's not about attendance now.
Okay, okay sir.
So any difficulties with respect to anything discussed?
No, sir.
Okay.
No, sir.
Okay. Okay. Then if you missed your attendance, just type it here in the chat box. And those who already got their attendance, you don't need to. If you missed it, then just type it in the chat box. Okay, take care.